All right, Mr. Washington, can you hear me?
Yes, I can, Your Honor.
And is the opposing counsel here on the trial setting for tomorrow? Is anyone else, Mr. Washington, are you here on the Independence Fuel Systems versus Toledo Gas case?
Yes, Your Honor, I am.
Is opposing counsel here?
He said he was, yeah, he said he was going to be calling in. I just got off the phone with him.
Okay, I think he's signing on right now.
Okay.
Mr. Cercelli, are you there?
Yes, Your Honor.
All right, I think both sides are here on this Independent Fuel Systems case. You guys are number one on the docket for tomorrow, and I'd heard you guys might follow a continuance, but we haven't seen one, and so we just wanted to get a feel for how long the case will take and all that kind of stuff.
Okay, well, Your Honor, we did file a continuance this morning. I'm not sure if it has not made it to you yet. It was e-filed this morning. It's been accepted. I can email it to you if that will expedite things.
Well, let me, I'll share screen. So this is, I don't see, if you can see this, I don't see any summary judgment that's, or a continuance that's been filed. Is this the right case?
This is the right case, Your Honor. To the extent I can see that. It was filed this morning. I want to say it was filed about 10:30. Vince, do you know what time?
It was.
It filed at 10:47, but when I received it, and it's not file stamped, but I did receive it at 10:45.
Okay. Well, this case is, relatively, it's over a year old. It's a non-jury. I guess there's another case was consolidated into it. Kind of what still needs to be done on the case to get it ready? Would y'all be ready maybe next week? Or what do you still need to do?
Well, Your Honor, look, I can speak to that. In my motion to continue, you will note that I'm also filing a motion to withdraw. I have had a series of health issues dating back to January and ongoing. I was actually just released from the hospital last Tuesday.
I'm sorry to hear
most
that.
recently. So given my health issues, I have literally been in the process of shutting down my practice. I actually thought I had filed a motion for a continuance and to withdraw in this case already. And this is one that somewhere in the process of being in and out of the hospital fell through the cracks. But the reason that we are seeking the continuance is not that my client's not interested in pursuing the claim. It has literally been health related to me. And that is kind of where we are and why we are here. I literally physically have not been able to try a case.
Okay. Well, I don't have a motion to withdraw or a continuance that's been filed.
Right, and that's what I was saying. The motion for continuance was filed this morning. I actually am working on the motion to withdraw. That will be filed this afternoon. I said I would be filing it contemporaneously with the motion for continuance. I don't know why that continuance is not showing on your end yet.
Rhonda, can you call Marissa to see if she has that? Maybe you can put it into mine.
Yes, I'm calling her now. Marissa, are you on the phone?
What's the case number?
DC 23-08242. Independence Fuel Systems.
And e-file, I don't see one on Odyssey.
They said they had just sent it in around 10:30 or 10:45 this morning. A continuance.
Yeah, it probably hasn't been accepted. I can go in and accept it if they did it at 10:45.
Okay. If you're able to, can you go ahead and just throw that in the judge's queue real quick?
Yeah, I can.
All right, thanks. She's going in and trying to see if she can see it and accept it.
Did she, I couldn't tell, did she say she sees it or that she,
She didn't see it. She said she'd have to go actually into the e-filing system part to see if it was submitted in there. And then she said that if she sees it, she'll go ahead and put it into your queue. But if they got an accepted confirmation, then it's most likely in there, but she has to, go through that. It's gonna take a few minutes.
Ms. Benson, I forwarded just my, the service email just to you and copied Mr. Washington, so you would have it as well.
Okay, let me look at that real quick, just a second. Oh, okay, I see it on here. I'm gonna copy this. Judge, he sent me a confirmation of the e-file continuance that he sent. Did you want me to bring it to you?
sure.
Okay.
So, did you also file a motion to withdraw?
I know I've not had a chance to do that yet. I will be filing that today or later this evening as well.
You have a law partner named Valdez?
I do. He actually, ironically enough, just had a liver transplant recently. So this is not something that he would be able to try. We have essentially dissolved the partnership. I've not spoken with him probably in 2 months.
Okay,
We have not had a very good, well, I guess the liver transplant was a blessing for him. We've had some health challenges this year, and that is what caused us to
sounds like it. I'm
go
sorry to
down
hear that. Well, let's go ahead and we'll set this, you need to get this motion for continuance on file, motion to withdraw. Let's go ahead and set this for November 12th.
Okay.
Actually, you know what, Rhonda, let's set it for November 19th. That work for both sides?
Yes, Your Honor.
That works for us, Sean.
And I'll
Thank you.
work with Mr. Washington with successor counsel or whoever it ends up being. So I'll work together with him, but that works with him.
Okay. All right. Well, good luck, Mr. Washington. I hope you recover quickly, and we will go ahead and get this case moved off the trial docket. But we do need to move forward on that. So get us whatever the motion to withdraw in as soon as you can.
Okay, I will get that filed as quickly as possible. Thank you very much, Honor.
Thank
All
you.
right.
Thank you, Ms. Benson.
All right. Grozier versus Perez Trucking, are both sides there?
Looks like everyone, Your Honor. Yep, we're here, Your Honor.
Yes, Your Honor, we're all here.
All right, let's go on the record on DC 226912. Grozier versus Perez Trucking. Council, make your appearances.
Yes, Your Honor, it's Jeffrey Wolf on behalf of the movement Jago Public Company.
Christy Hester here for the plaintiff Patrick Grozier.
Baxter Banowski for the intervening plaintiffs, Your Honor.
Jeff Seeberger for defendant Weber LLC.
Tom Needham here for the Perez group of plaintiff of defendants.
All right, let's proceed.
Your Honor, housekeeping issue first. The parties had agreed that you could hear a motion for continuance that's been filed on the case today. We're currently set on the 13th of next month, and had been called to trial down in Johnson County on the 12th. And the case is going to go. And so it's a much older case than this one. And so I just wanted to bring that to the court's attention and ask the court to consider the motion for continuance, as all the parties have consented for you to do today.
Okay, we'll deal with that after the summary judgment.
All right. Let's focus then on the summary judgment issues. As the court will recall, we had some summary judgment arguments previously in the case when the plaintiffs had moved. I hadn't seen the court's actual ruling on some of that, but I think it's important for today's hearing. We are certain issues that I think we can clean up as a matter of law. And then there's one issue that I think the court has to decide if there's a fact issue or not. And so I'd like to focus in on go issue by issue. And I hope the court has received the notebook that we have provided. It was deemed delivered this morning. Do you have a copy of the notebook?
I have not seen it. Can you see if Rhonda or Marissa has this notebook? I had not seen it, but we'll grab that.
It's important to kind of walk through the notebook together. Can we wait just a moment for the notebook?
Sure. Yeah. I've got it.
All right, very good. Your Honor, I'd like to just kind of go through the legal arguments with you and tell you what's in the notebook. First of all, in the pocket, there is the motion for continuance that the parties have agreed you could hear today, as well as proposed order on this. It kind of breaks it down issue by issue. And that's sort of the order of the issues that I would like to cover with the court, starting with the issue about motor carrier status. And within the notebook itself, Your Honor, back in the back is the law that kind of goes with the various motions. And under tab A is the law that goes with this first issue about motor carrier status. And so this is a legal issue, I believe, for the court. And as a matter of law, Jago Public is not a motor carrier vicariously liable for the acts of Perez Trucking and his drivers. Quick background on the facts of the case. There was a staging area on a paving job site that was on Loop 12. Related to that, there was a general procedure that the trucks get in line, and the order that they arrive and stay in line until they're supposed to back up to the paver. Mr. Grozier, who was an employee of Perez Trucking, was outside of his truck. Mr. Perez, who was behind him, backed around him and backed over him. So the question is Jago a motor carrier with respect to Perez Trucking? There's two different, as you look at tab A and turn the page with me, Your Honor, there's two different definitions that I think are dispositive in one case that addresses the issue. 49 CFR 390.5 down on the bottom. As the court can see, employer means the person who owns or leases a commercial motor vehicle in connection with that business or assigns employees to operate it. The evidence in this case is undisputed that Perez Trucking did that, not Jago. They own these two dump trucks, and they assigned the drivers to operate each of those two dump trucks. And so under that definition, clearly Jago would not be a motor carrier or an employer under the Motor Carrier Act. Turning to the next page, you can see that within the transportation code, there's a definition of motor carrier. It is an entity that directs the operation of one or more vehicles that transport persons or cargo over a road or highway in this state. And in this case, all of the direction for travel over a road or highway was done by Perez Trucking. None of that was done by Jago. Jago was simply a shipper. And the controlling case on this issue, Your Honor, is if you turn the page with me again, you'll find the Gonzalez versus Ramirez case. And the court looked at these very definitions and said that a shipper is not a motor carrier, even though they controlled the loading side and the unloading side. Loading and unloading trucks does not make one a motor carrier. The court focused on the fact that the shipper didn't own or lease the trucks or assign the drivers. They didn't have anything to do with the permits or the insurance. They didn't control the hauling operation over public roadways, and they didn't determine the route. All the evidence in this case is undisputed that those are responsibilities of Perez Trucking. And so on the basis of those definitions and the controlling case from the Texas Supreme Court, Jago would not be a motor carrier as a matter of law. This case, the Gonzalez versus Ramirez, is also a good case to segue into our next issue, that Jago did not control.
Let's deal with these issues one at a time. So let's deal with the motor carrier issue first. So
Okay.
let's hear from the plaintiff on that.
All
Thank
right.
you. First, going backwards with respect to the Gonzalez case is not applicable here because the Gonzalez case is a situation where between point A, where trucks were picking up, and point B, where they were unloading, somewhere along that route, that's where the accident happened in Gonzalez. That's not the case here. The case here, the accident occurred in Jago's work site, which was under Jago's control. And what the statutes say first, what the evidence says, Jago's corporate rep agreed that this job site was taking place on Highway 114 westbound at 482. So if we look at the Texas statute, the Texas statute says you're a motor carrier if you control, operate, or direct the operation of one or more vehicles that transport persons or cargo over a road or highway in the state. And so Highway 114 is obviously a highway in the state. Council referred to it as Loop 12. We all know where it is. And so the only question is, was Jago involved in directing the operation of these dump trucks? And the answer to that question is yes. First of all, included in the summary judgment evidence is the portions of the deposition of the plaintiff's expert, Chip Darius. And what Chip Darius testified to was, in response to the question, did Jago give Mr. Perez any specific direction that it could go around Mr. Grosier's truck? What he testified to was, no, Jago did not give any specific direction to any specific truck operator in this case. Instead, they gave a general direction to back all of the trucks at once. There was 4 trucks there waiting in a line, and Jago's foreman on the job gave them all collectively the direction to start backing. And so when we asked Domingo Salazar, who was the last truck driver in line, there was 4 in line. It was a guy by the name of Choney was first, and then Mr. Grosier, the deceased, was second. Then Mr. Perez, who ran over Mr. Grosier, was third. And then Mr. Salazar, Domingo Salazar, was fourth, basically at the end of the line. It's important to note that Mr. Salazar is an actual Jago employee driving a Jago truck. And so the question was, who gave the signal when it was time for all the trucks to move? And Mr. Salazar said, well, Franco, that's the Jago foreman on the job. Franco told me to go in reverse. And then the question was, can you tell us where it was when he gave you the signal? And he says he was at the paver because everybody was going to go in reverse. Then he goes on to describe the order of events, and he says, it's just like a convoy. The first truck starts backing up, you give him, let's see, the first starts backing up the paver, the second truck will actually start following, and then the third truck comes in and goes and follows the second truck. And Mr. Salazar, Domingo Salazar, who's their employee, testified that at the time of the incident, his truck, he was last in line. His truck was in reverse. He was ready to go. And so the question was, and you see the signal, and then everybody goes to get in their truck. Choney, that's the guy who's first, starts to head that way. Mr. Perez starts to head that way, and you started heading that way. Answer yes. Backing up in reverse. Answer yes. And so, so Jago is the one that is instructing. Jago's the one who decides how many people pile up in this job site. It's undisputed that Jago is in control of the job site. These drivers are not free just to kind of come and go as they please. It's not a situation where they just drive in and back to the paver. No, they enter the work zone, and then they enter under the control of Jago. Additionally, if you look at the definition in the federal regulation of what constitutes an employer, it says an employer means any person engaged in the business affecting interstate commerce who owns or leases commercial motor vehicles in connection with that business. It's undisputed that Jago owns commercial motor vehicles. In fact, Domingo Salazar was driving one of those. And then the question is, what does it mean to be an employee? And this is where I think the main issue is, if I can share my screen, what the regulation says.
Go ahead.
Sorry, I'm trying to get it squared away here. What the regulation says is employee means any individual other than an employer who's employed by an employer and who, in the course of his or her employment, directly affects commercial motor vehicle safety. Importantly, the regulation specifically says it includes a driver of a commercial motor vehicle, including an independent contractor while in the course of operating a commercial motor vehicle. And so what we have here, unlike the Gonzalez case, is we have a commercial motor vehicle being operated by Roberto Perez under the direction of Jago Public Company. And when Jago Public Company gave all four of these trucks the direction to proceed backing, that's when Mr. Perez ran over and killed Mr. Grosier. And so with respect to the Texas statute and the federal regulation, we tick all of the boxes that Mr. Perez was acting pursuant to the terms of the federal regulation as an employee of a Jago at the time that the incident occurred, because at the time that the incident occurred, his commercial vehicle was being directed by Jago. At the very least, there's a fact question whether or not it was under the direction of Jago at the time that the accident happened.
All right. And Mr. Wolf, we don't have a whole lot of time left, so you want to kind of hit your best points at this point?
On that one, Judge, I think you need to read the case that I've cited you to. Mr. Darius said there was no evidence that Perez was employed by Jago. He conceded that point. He conceded that Jago, and you can look at page 6 at the top of my reply brief that talks about Darius's testimony. He says that Jago did not maintain control at the truck staging area, and they did not provide ground persons. They didn't do that. Was Jago exercising any control over Perez Trucking and its employees to follow its safety policy while they were in the staging area? Well, if Jago had done so, we wouldn't be here today. So the answer is no, they didn't. He conceded they exercised no control while these trucks were in the staging area. That's dispositive of not only that issue, but the next issue. And if you go on in the Gonzalez case, Your Honor, related to that, what is important to note is that the Gonzalez case goes on to say that in order for there to be control, you have to have knowledge of the dangerous activity and specific approval of the dangerous act. There's none of that here. There's no knowledge on the part of Jago that Mr. Perez would go around his employee and back around him out of order. The job site procedure was to get in order and stay in order all the way to the paver. Safe work instructions, Your Honor, and safety policies do not create a duty of control. I would, under tab B, Your Honor, I would refer the case for the court specifically to the Dow Chemical versus Bright case. There's a couple other cases before that. They cite the Jago Weber contract as providing a basis for a right of control, but there's no right to control the manner, method, or details of the work of Perez Trucking on the part of Jago. The only agreement that relates to that relationship is a transportation agreement, which we've included in the summary judgment evidence, and there is no right to control the manner, method, or details of the work on the part of Jago as it relates to Perez Trucking or its employees. So then the court's analysis must go to actual control. The Supreme Court in the Bright case says it must relate to the injury the negligence causes. Safety policies, it's a narrow duty. Do you unreasonably increase rather than decrease the probability and severity of injury? If Jago's policy of staying in order had been followed, this accident couldn't have happened. If Jago's policy as it applied to Mr. Grozier of staying in his truck and keeping his head on a swivel when he was on the job site, again, Your Honor, there is no control in that respect. The contractor, according to the Lee Lewis construction case, and I know the court's familiar with that, must have prior knowledge of the dangerous act and specifically approve the dangerous act. For example, in Lee Lewis construction, the contractor knew about the scaffolding and approved it and told them they could go forward and work. In this case, Jago had no knowledge Mr. Perez was going to back around his employee out of order, contrary to the safety procedure at the job site. The coking refining case talks about safety rules, Your Honor. The Fifth Club also talks about the necessary control to trigger a legal duty requires more than general direction on how to do the job safely. It's in the notebook. It also talks about this issue of a non-delegable duty that says the activity itself.
Did you want me to hear the summary judgment today or no? Because you're running out of time.
Yes.
I'm sorry, did you want me to hear the continuance motion?
I do.
We're running out of time. So it's up to you. If you want to keep going, you can, or
I think I've told the court the basis for the motion for continuance earlier, and I would ask the court to rule on the motion based upon what I've
I think 2 of my first 3 summary judgment responses I wrote as a young lawyer were on the right to control in the construction side. So I'm pretty familiar with, I'm board certified in personal injury. I'm pretty familiar with this area of law. I think I told you guys when I thought I told you I denied the plaintiff's motion that I was probably I think there's clearly a fact issue here on the right to control. This issue involving OSHA and the Motor Carrier Act, I'm not quite as familiar with. So on the right, just general right to control, which I guess is subsection B, I'm gonna deny. On the rest, I'm gonna kind of take that under advisement. So if you could go ahead and get me an order, if I haven't signed one already, denying all the plaintiff's motion and then denying the summary judgment as to simply right to control, which is subsection B here in yours, and then the rest, just say I've taken under advisement. Mr. Wolf, if you could prepare that and share it with opposing counsel and get that to me. Make sure that it indicates at the beginning that this was heard on July 22nd over Zoom, and that try to get that to me by tomorrow if you can.
I shall.
Cassidy.
Do Your Honor have a ruling on the continuance, Your Honor?
Yeah, so I wanted to kind of chat with you about this. I'm sure you've heard this from other judges. You know, there's this new bill that was passed by the legislature about continuances and about they now say if they judge us on if cases are 33 months to 6 months, 6 months to 12 months, 12 months to 8 months. And if our cases get too old, they're threatening to, under the statute, to give us mentoring judges to teach us how to judge, which I've been doing this for 18 years. I wouldn't like that. Not that there's been any suggestions I need one, but it has made us a little bit more wary about granting continuances. And then that's the first issue. The second issue is, you know, this is not my first rodeo. If I continue this, I know what's going to happen is I'm going to get another 8 summary judgments on this. So if you guys want a continuance, I would need to, you know, all the continuances should have been heard and filed by now. So I would want to have a moratorium on any additional, I'm sorry, not continuances, summary judgments. So I would want a moratorium basically on any more summary judgments being filed. Or we could just go forward on the 13th and just see what happens. What do y'all think?
Your Honor, I'm perfectly fine with a moratorium on summary judgments. We filed ours, and the court has ruled at least on the one issue, and I would hope the court would rule on the other issues as well. So I'm fine with a moratorium on summary judgments if there's a continuance, but I'll let these other parties interject. I do know that we will go to trial down in Johnson County on the older case.
The Perez group has no group of defendants, has no intention to file a summary judgment at this motion, at this time, Your Honor.
And Weber has the same position.
Anyone else?
Your Honor, the interveners, under the circumstances, are not opposing the motion, subject to a concern about sort of, you know, work available being, you know, kind of expanding to fill whatever time is available. And we've got a trial date and a scheduling order that has certain pretrial deadlines. And we'd like to, if we move the trial, what we'd like to be able to do is finish doing whatever the pretrial work is we have to do today for our August 13th setting. And then if we're not going to get reached, which is what I understand probably is going to happen, then we basically can shut the case down, put it in a box, and then when we come back to our new trial date, we can unbox it and go to trial. I guess what I'm saying is we don't want to then have this be, now we're going to do much more discovery.
I don't think that's unreasonable at all. How long is your trial going to be, Mr. Wolf?
We've told that court at least 5 to 7 days, so it'll spill into the second week.
Do y'all want to be reset to like September 3rd?
I'm scheduled to be out of the country starting on the 4th for 15 days, Your Honor.
How long is this case going to take to try, do you think?
Probably a good 2 weeks.
I was thinking 2 weeks as well, Your Honor. And I just like to have, I think we're currently set number 1, and we were prepared as if we were going to trial on the 13th. So we really have been, moving as diligently as we could to be prepared to do that. If we're going to get reset here by agreement, I sure would like to get reset at a time when we're going to be the oldest case on the current trial
Yeah,
docket.
you are number one on the docket.
We'd like to keep,
Maybe y'all want to keep, I mean, one option would be to just keep the date and see if he goes to trial on that other case. I mean, I know attorneys are like, it's absolutely going to go. And my experience is that's a 50-50 at best. Because sometimes the judge has a carryover case, or the judge can't try it, or the case settles, or whatever. So I know it's possible that the case goes, and of course we would defer to it if it's an older case. But if you all want to just keep it on the 13th, I'm okay with that too.
I think the problem with that, Your Honor, is a logistical one with respect to all of the witnesses that need to get secured and made available. You hate that.
I mean, another option would be we could specially set this case, but a special setting is set in stone. You cannot move it. So what are y'all's thoughts about that? Not for that date, but for a different day.
I think that would be good, because I know we have witnesses coming from all over the country with respect to experts and so forth. I think what I'm saying, Your Honor, is we'd like an opportunity to find out what the available dates would be, and then check with our witnesses, and then report back, and then just pick a date when we know we can go, and then we'll all put it on our calendars and plan to go.
I'm
Right.
fine with it, Your Honor.
Right, does Your Honor have some that we can kind of ping pong around, since there are so many lawyers, and I'm sure there's vacation lawyers everywhere?
It's challenging because just as much as you guys have a lot of cases, I have a lot more. So I kind of need to do this with you because I may tell you 3 dates, and then I may get a special setting on one of those dates. So I know it's a little challenging. Why don't we do this? My computer has stopped working. Great. You say it's going to be a 2-week trial? Is that what you said? 2 weeks?
That's fair, Your Honor.
Let me pull up my calendar. I don't know why. Ron, have you had problems with Odyssey today, or?
Somewhat signing in, it was a little problem, but not too much.
Yeah, it's all of a sudden just not pulling up the calendar.
It's letting me do it. Did you want me to look at something particular for you?
No, let me do this. Let me try one more time and see what's going on, and then if that doesn't work, I'll go into your office.
Okay.
So what I would suggest we do is I'll give you a few dates right now, and then why don't you sign on to Zoom tomorrow at 9 in the morning, and we can go over the dates and pick one. I don't want to. That's what usually works best. Hopefully, in the interim between now and tomorrow morning, you guys can check these dates. I don't know what's going on with Odyssey.
I like that idea.
Well, Odyssey's not working for me. I don't understand it. Okay. All right, Rhonda, I'm gonna go into your office and see if we can figure out some dates.
Okay.
Y'all hear me okay?
Yes,
Yes, sir.
Yes, Your Honor.
Okay, let's look at some dates. How does, so I'll give you these dates, October 1st. So, going. October 8th. October 15th. October 22nd. October 29th. So if you guys can't agree on one of those dates, we just keep the trial setting we've got. Okay?
Thank you, Your Honor.
Thank you, guys.
Thank you, Your Honor.
thank
And we
you.
will see you
Thank
tomorrow
you.
morning at 9 on Zoom.
We'll see you then. Thank you, Judge.
Thanks.
Your Honor, if we have, an agreement as to dates, does the attorney have to be present, or can we have a paralegal sign in the morning and say okay to the dates?
I'm sorry, say that again?
Myself, and I don't know who else is setting other hearings tomorrow morning. Would it be necessary to have an attorney, online in the morning, or if we give the dates we can agree to, could we have a paralegal sign in on Zoom in the morning?
No, you're not, you can't have a paralegal do it, but if you want to designate one of the other counsel to speak on your behalf and it has your schedule, but.
Okay. Yeah, that'd be fine, Your Honor.
Okay.
Okay,
All
thank
right,
you.
anything else, guys?
Thank you, Your Honor. No, not
That's
yet.
it. Maybe,
Thank you, Your Honor.
Thank you, guys.
Your Honor, may we be excused?
I'm sorry, yes, you may. You have a great rest of your day.
Your Honor, you too.
See you in the morning.
Thank you, Judge.
Okay, next case is at Corey versus Strage. Are you guys both here?
Yes, Your Honor, we're here.
Yes, Your Honor.
Is it Ms. Whitaker and Ms. Hoffman?
This is Jennifer Rynell, Wilson Whitaker Rynell, and John Wilson is here as well.
I'm sorry, I looked at your middle name instead of your last name.
Oh, that's okay. It's that, yeah, we put the whole firm name on here in case.
I'm the Wilson, she's the Rynell.
Okay.
Hi, Carrie.
Oh, okay, sorry about that.
Carrie Hoffman and Brooke Ballinger are on for At Court Inc., Your Honor.
It'll be. There we go. All righty. So let's go ahead and chat about this. So this case is it correct that this case is closed?
Yes, Your Honor, this case settled and was closed, I believe in January, it might have been early February of this year. So
Go ahead.
I'm sorry. So we're here on our supplemental briefing on the motion to seal that we filed several months ago. And we had discussed in our last hearing whether there was case law supporting a motion to seal in this context. And the bad news is that we were not able to find any in this specific context. And the good news is, I guess, that AdCore wasn't able to find any saying it was not proper in this context. So I think where it leaves us, there's very few cases, like if we submitted to the court our entire search results for the Rule 76A. And there was only I believe it was either 193 or 196 cases, the vast majority of which were not even remotely relevant to what we're hearing today. The good news is that it is 100% within your discretion to do what we're requesting under the rule. And, as long as the court follows the guiding rule and principle in Rule 76A, it's an abuse of discretion standard. And, it's likely, not. Basically, there's Supreme Court case law that says that, you don't look at analysis of the facts on any appellate review of such a decision. They just look to see whether the court followed the guiding rules and principles, which are set forth in our briefing and fully within your discretion.
Ms. Hoffman?
I think the issue is, Your Honor, they haven't met the standard, which is they have the burden to show there's no less restrictive means. And they don't really even go into any of that, meaning there's nothing that indicates that this is the reason he can't find a job. This is just their supposition. There's nothing new or different than when we were last time. Last time the court said he wasn't inclined to seal the records unless there was some basis for which to do it. And there's just no basis that's been presented that overcomes the presumption of openness of court records. Otherwise, every one of these cases is going to be subject to seal because someone's going to claim if they're unemployed that it's going to have that it's having some impact on them.
I mean, just, Your Honor, may I respond?
Well, let me ask this. Have there been any potential employers that have actually said that this is why he didn't get a job?
Your Honor, Mr. Schrage is on the line here as well. I don't know if you want him to respond to that or if you want us to. But basically, he's been informed, for positions that were perfectly suited for his skills that he didn't pass a background check after, several interviews. And there's no other reason that would be the case. And if you put in his name to search, it's one of the first things that comes up. So, this is, and, as Ms. Hoffman mentioned, that if you granted in this case, there'd be, all these other people that wanted to grant it. And that's just simply not the case, Your Honor, because 6 counsel basically on this case haven't been able to find anything analogous. So it's not go ahead, Mr. Wilson.
Yeah, and Your Honor, he's a high level employee. He's a VP executive type with extreme knowledge in his particular industry. So he's not like a regular employee. He has advanced technical knowledge, writes books on the subjects. So they're going to look out and see this out there, and they're not going to want to hire him, given the fact he's going to be put in these high level positions. They're not like ordinary jobs. And I think Mr. Schrage can speak to that if we want to get him on the phone. But one of my positions is that, we expunge criminal people's records to allow them to get jobs. And he's done nothing criminal, yet by analogy, we expunge criminal records for other people. So it makes sense to do this for him, to allow him to get a job.
But Your Honor, twofold. One is that if he's failing background checks, there are means by which to deal with that through the Fair Credit Reporting Act. No evidence of that's been submitted to this court, meaning if that was the case, if he was being denied employment based on background checks, we'd be seeing that. If it's internet searches, to me, you're not going to wipe the internet clean anyway. So to the fact that this lawsuit exists will still be a footprint out there on the internet. So it's not solving any problems.
Right. I think it's fair to give this guy a shot to at least have something that
what exactly are you asking to have sealed?
Your Honor, it's they are listed in our motion. It's actually less than what is permitted by the rule. Orders are not permitted to be sealed. We're asking for the initial petition and the proposed TRO that went with the original petition. Proposed order for expedited discovery, plaintiff's motion for expedited hearing and discovery. And then there's other proposed orders, Rule 11's notices. But the actual orders issued by this court were not seeking to seal, which is in conjunction with the rule, as well as hearing notices submitted by the court and other things like that.
So again, there's going to be a footprint of this lawsuit that in theory is still going to be out there for him. It's not going to resolve this issue.
Well, it lessens the blow, Judge, of this particular case existing.
Again, assuming that's the reason he's being denied employment.
And he's welcome to get him on the board. Judge, he's here with us if you want to talk to him.
Is there something really inflammatory in these?
It's
Absolutely, Your Honor. It's, they moved for a TRO and they claimed that he basically stole company confidential records. And that those allegations were not even close to proven. They're not even true. And Your Honor, it's basically they had a huge pleading. Their first pleading was, many, many, many pages of allegations that were never in any respect adjudicated. And we're not accurate.
Not because they weren't accurate, Your Honor. I mean, we highly contest that position. We had proof of downloading of information, and our lawsuit was very typical of what a lawsuit looks like in a non-compete breach of confidentiality theft of trade secret case. It is not an atypical pleading in this type of matter.
And we're not disputing that it's atypical or typical, but basically, the analysis here is whether there's, financial, reputational, privacy considerations. Those are the things that other courts have looked at and found to be proper bases to seal. And those all exist in what Mr. Schranke has verified here. in this case.
Remind me again, did I ever grant or did any judge ever grant a TRO on this?
Your Honor, you granted a verbal order, but there was never a signed order.
Despite the many times we brought it to the court's attention to have it signed.
And Atcor never paid the bond,
We didn't
$5,000
pay
bond.
because we had no signed order and therefore had no to pay.
Yeah. So no bond was ever paid, no TRO issued.
Again, verbally it was issued.
But we're not seeking to.
But the case, okay, so the case settled.
Yeah.
Yes, Your Honor, settled at mediation.
All right, I'm gonna allow the original petition, the TRO proposed order, and anything else that mentions misappropriation that you requested to be sealed. So go ahead and give me a new order on that with the exact documents that have that in there. And make sure that it says at the beginning that this was heard on July 22nd, 2024, and get that to me by tomorrow, okay?
Thank you, Judge. We absolutely will. We greatly
And
appreciate
share that with Ms. Hoffman.
I will, yes.
John, are we excused?
You guys are excused. You have a great rest of your day.
Thank you, Judge. You as well.
All right, guys. We have another hearing at 3:30. Why don't we have all the interns, it's just us, right? Oh, Mr. Schrag is still here. Let me go ahead and let him go. All right. Why don't we have everyone, we have some new interns that started today, or just Sam, I guess. Sam, why don't you introduce yourself to all the interns, and then every one of you can introduce yourself to Sam, for those who haven't already done that, because I think some of you already have. So those of you on Zoom that haven't introduced yourself to Sam, go ahead and introduce yourself.
I think
Did
we've
you-
all introduced ourselves,
Everybody's
Judge, those of
introduced,
us.
okay,
Yeah.
okay. So I don't know if you guys had already heard, it looks like our trial doc went down to one case. So we may or may not have a trial tomorrow, but we'll see. And we have 3 lunches left. I wanted to so Sam, the way this works is we're going to lunches with at different firms right now. And we have 3 left. You get to go on one, Leanne gets to go on one, and Cassidy gets to go on one. So we have Kirkland Ellis, Foley Lardner, and DLA Piper. Leanne, do you have any preference between those?
Are any of them on Friday?
Yes.
I'll go on the one on Friday.
Okay, that's the Kirkland one. Do you have a preference? Wednesday or Thursday? Okay, then you're going on the DLA Piper one. If you want to, you might want to write that down so you have it. And that'll be at noon. So as the most experienced member of our intern team, Bella, why don't you go ahead and tell Sam how the lunches work?
Okay, so basically they're just kind of networking lunches, so there'll be, I'm assuming all of the one you'll be at will be at the firm, so we'll go and they usually have lunch, they have lunch for us, and we can sit down. And they'll have like this, like a group of attorneys, and we'll know who they are beforehand, so we can do some research and just kind of familiarize yourself with the firm. And we all stand up and give like a little elevator speech. So just about you, you know, hi, I'm Sam, I go to Texas A&M, I'm in law school.
Why don't you guys do a practice one? Emmy, why don't you do your elevator speech?
Hey.
You got to stand up.
Hi, my name is Amy Burgess. I'm from Fort Smith, Arkansas. I just graduated in civil knowledge from the University of Mississippi with a degree in public policy leadership. In spring, I was inducted into the 2024 Homeless Hall of Fame, which is about 10 students chosen from 4,500 graduating seniors. And for the past 2 years, I've been a producer with the Women's Health documentary called Fuller Belt and Women's Health. Beautiful.
So you get a feel for what, so let's practice yours.
Hi, my name is Sam Kim. I'm a writing sophomore at Texas A&M University. I'm currently majoring in English honors with minors in legal foundations and business administration. I'm currently a secretary of the Texas A&M mock trial team. I'm on the varsity team, and I've been doing mock trials since freshman year of high school, so about 6 years now. And I'm also deeply involved in the moot court as well at Texas A&M. And I'm very interested to go to law school.
That's great.
That was good. That was good. Let's try again.
Oh, okay.
So let's tighten it up a little bit. You see how hers was just like really flowed. So let's tighten it up. Let's practice again. It was good. It did slay. Is that how you use the word? Correct? Slay. Did I use it correctly, guys? Jack, did I use that right? Jack, you're a little older, maybe. Leanne, did I use that correctly? Okay. All right, let's try again. Let's tighten it up.
Hi, my name is Sam. Currently a rising sophomore at Texas A&M University. I'm studying English, business, and legal foundations. I'm deeply involved in Texas A&M's mock trial team. I'm an officer there as their secretary, and I've been doing mock trial for about 6 months. And I'm also in the moot court at Texas A&M University, and I'm also in the Free Law Society. I'm deeply interested in going to law school and specifically in civil procedures.
So civil procedures isn't really an area.
Litigation.
Civil litigation, yeah, probably civil litigation is a little bit better. So
Like after you say it fully once, the rest of it, you probably know better than I would. But
no, that's good.
And like the rest of the time, like on an A&M.
Yeah, you want to just think about tightening it up. They practice this many, many times. They're getting better and better each time. So that was a great first try, and you just got to tighten it up. Think about, why don't you practice in the mirror? You've done where did you do mock trial? West. So that's a pretty good mock trial team. And so just tighten it up like you would an opening statement. My son did mock trial. I don't know if you knew that, but what?
I'm an opener.
Oh, you're an opener. So yeah, so you get it. So you just got to memorize it, get it down, and try to get it under like 25 seconds. Ripped it out. That was a great start though.
Yeah, and you can just say, yeah, that was great. Like, I'm really interested in mock trial, and that's why I want to go to law school. And like, I mean, you can definitely put civil litigation if you want to do that, but you don't have to. They're not going to expect you. But if that's what you know.
Yeah, civil litigation is good, and the fact that you've been involved, and something else you might want to say, something along the lines of, I've been involved in mock trial. I've known I wanted to go to law school since, I was a freshman in high school, and have done mock trial ever since, or something along those lines. It would be good, but it's good. Good job. All right. All right, we have another hearing at 3:45. Does anyone have any questions about everything? Is everyone, Leanne, how many memos have you gotten so far?
I've gotten 5.
So who has not sent you a memo yet? We have, I guess, a total of 9 law students. So who has not sent you?
There's I've reached out to a few people to make sure to see whether or not they were gonna send. I might be missing a person because I've reached out to 3 and know where theirs are, and I have 5. So I think I might be missing one.
Archana, did you send yours?
My memo.
Yeah.
Hello.
Yes, did you send your memo?
Oh, no, I talked to Leanne. I was under the impression it was due tonight at midnight. So I don't know if I'll be able to send it by like 5 p.m., but I just I don't have to send it for the competition. I just wanted a writing sample that you've seen. Um, so I don't want to make it inconvenient for other people.
So why don't we, so Leanne, are you gonna be up at midnight?
No, I'll be done before midnight. I'll be done by like 6 or 7. I just need some time that like not in a meeting to like go over some things.
All right,
I'll
so
be up
Leanne,
until at least 10 or 11. I don't know when I'll be back on campus.
what I'm gonna do is I'm gonna connect you with Caitlin and Blake, and then once you get, we'll talk to everyone, but once you get all the memos in, then forward it to her tonight, because she doesn't have a lot of time to, she's gonna read, her and Blake are gonna read all of these.
Okay, that sounds good.
All right, what about you, Jack? You said you did not want yours forwarded, is that right?
Yes, sir, that's correct. I have an interview with Munchhart tomorrow, and I already have like a writing sample that I feel like would demonstrate my writing ability better than this current one that no one else has looked over besides my eyes. So that's why I'm a little bit hesitant because I know it's one of the attorneys at Munchhart reviewing them. So I feel like it would be better if I gave them a writing
So is one
sample.
of the people interviewing you also judging the competition?
Mine's with Ross in person tomorrow.
Well, he won't be judging the competition, it's just Caitlin and Blake. I don't know if that
I
makes
mean,
sense.
I would still not prefer it, but if you feel like it needs to be done, then obviously, okay.
You don't
Would
have
you like me to send yours, Jack? Do you want me to send yours to Hoffman and then only the 4 other ones that I have, or maybe with Archna's it'd be 5? Or do you want to just not send it?
I mean, send it to Hoffman, yeah. Because obviously I would like a writing sample from Judge Hoffman that he's been able to look over. I'm just hesitant about sending it the Munch Heart without anyone else reviewing it, if that makes sense.
Okay. Kate, what about you? Have you already sent it?
Yes, I sent mine to Leanne this morning.
Would you like me to tell you whose I have?
Yeah.
I have Kate's, Jack's, Sam's, oh, hold on, Savannah's, and Keegan's.
All right, what about Waze? Have you sent yours?
He's reached out to me and so has Jordan.
And what have they said?
They said neither of them were submitting.
They're not submitting not submitting their memos?
Correct.
Judge, I got caught up with the COVID. That's one of the reasons. The other, I was working on a CPT application. So I might have a delayed submission.
Okay. All righty, well, it's what it is. So. We have, just get me and also send it to me. I'll, email Caitlin and Blake and
Would it be of any help if you gave me their email so I could just email them directly, or do you want to be the
I'll,
third party?
no, I'll go ahead. Hey. How's it going?
Yeah, I think I reacted to. Oh my God. I do know. I was talking about this yesterday. I do know this. I don't know why I'm blanking right now. I'm so oh, I have, you're like, I like have no idea what to do to law school. Or I guess, so like, that's like really impressive. I have so like, it's years. Yeah, I mean, I'm. So you're gonna do junior, you're gonna be sophomore. I'm gonna be sophomore, okay. Yeah, you're ready. Yes. Yeah, I got really lucky in freshman year of high school because my friend told me about mock trial and I really didn't want to do it. Oh, that scares me so much. She offered me food and I went to a movie. I don't think we had it. Yeah, it's common on the high school level. But it's more common than what I know. Yeah. Seems like I've heard a lot of people, but we had a high school for the last 2 weeks. Yeah, I mean, we're gonna see.
No, Central is where she's like getting her
No, she's
associates with it.
doing like, I think, maybe she was doing. I did in high school.
Yeah.
Grade 4.
Hey, Bella, can you come on back?
No, I think like a lot of them you put out like it's awkward thing. I remember it was like this is that you that it's a little awkward. You know, so I think it's friends.
Yeah, he's gonna want you, I don't know if Bella said it, but he's gonna want you to prepare a question. Thanks.
Yeah,
So,
do you want me to which for? You know, like, let me just, just in case we forget to, let me just forward it to you. Did you got it or? I so this is not the next one, but
I don't know like all the attorneys' names on, so you can just look it up on like case of interesting to you, if you're interested in like their practice in some capacity. Their law school.
and you seem good on your feet, so. Yeah. For a little bit. I was big. I was more like a. I was in a fair. And but I had so many friends who did all of this. So not like that. I did stuff. Mostly in school. Honestly, not much. We did freshman year too. So yeah. I kind of want to focus on. I just knew I'd be mock trial. Yeah, like next year, I was like looking to more things to do. Because I can be a social spirit outside of mock trial too. Yeah, yeah. Because it gets very like close. We're so busy. And that's such a big school, but like you want to try to make as many close as you know. Like do a lot. That's fine and all. You're gonna do all the rest of your life probably. We're gonna need to do other things. I love like sports. I was involved in. That was a lot of fun. I know Anna was really. My friend was taking judo. Oh no, maybe I don't know.
It's senior year, and I just graduated. Good happened. I didn't do this, but other people did it. And they would take like interesting things that are very hard.
Tennis.
So right.
You know,
I would so think about.
I love how this fit in another life on the day.
That makes sense.
Yeah, yeah. Like you can argue that.
Like,
Here's another one.
You go to voting. Stay from there first.
Yeah. So why
Yeah. Give me feedback.
Yeah, yeah, because you don't care, you won't, you know.
Yeah.
Which number is it? Okay. Because they don't let you out. That's fine. You can find it out.
Never want to stop.
I think I'll get that impression. Okay. Yeah. Like, that's how it seems like. That's very. Excited for that era. It's okay. This was good. There's
So
lunch
much
today
time.
for the bustle. So nice. I would get to school. It kind of takes up so much of your life, but like it's hard not to. I bet you will.
Well, I'll leave that option open.
I thought I was gonna. Maybe I'm just letting myself. Part of it. Want other people.
Definitely part of it.
Don't feel out. And whoa, TV's on her. Yeah, she's over there.
Real, so,
Yeah.
several options.
You can't eat that way, but. Like, maybe. What kind of video? Fast. People are just saying that and they can't even understand what's on the video. And when I was talking up there and Tony was writing, I was like, purposely trying to talk so slow. And afterwards she came up to me, she was like, are you trying to test my skills right now? Like, she's having us talking fast. Right. So. Thank you. So I didn't decide till or middle of the year. So anyway.
Okay, guys, we have some more hearings. All right, is anyone here on the Espinosa? Sorry, we're running a tiny bit late today. Is anyone here on the Espinosa versus CBRE case?
Yes, Judge Gunnar Barber here for CBRE, and I won't hold it against you.
All right, thanks.
Brian Kennedy here on behalf of the plaintiffs Gabriel Espinoza and Julia Guajardo. No, it's not.
All right, let's proceed.
Judge, it's my motion, and we have what is an agreed motion to reset for the trial setting for October of next year because the plaintiffs just added 2 new defendants that need to work everything up. So I don't know if you want to hear argument on that portion of it. The second half to that motion is I'm asking the court to escalate discovery to level 3 and order expert reports.
All right, well, the first thing is, and I'm sure you've heard this from other judges, you know that we have this new legislation that has been passed and that has, we now get reported every time we grant a continuance, it gets reported to on the state website. A lot of judges have become very hesitant on granting continuances at all. We also are being judged on how old cases are. So 3 to 6 months, 6 to 12, 12 to 18, 18 to 20, 24, and then over 2 years. So there's a lot of concern about even granting continuances at this point, especially a case of this age, which is almost 2 years old. They're also talking about bringing in mentoring judges that would mentor courts, the cases where cases get too old. I've been a judge for 18 years. I have no desire to have a mentor judge. So that being said, I'm very concerned about continuing cases at all, but also cases of this age that have already been reset before and are this old. You had a new party added when?
Last month. Despite the age of the case, Judge, limitations has not even run until next month. I don't know if that weighs into any factoring.
You know what? I'd encourage you to talk to your legislator about that because that doesn't, as far as I can tell, it's the age the case was filed. And so I see here that there's a defendant CBRE that was filed back on 11/10. There's a Pinecrest Electric and a Jason Lee, neither of which indicate that on the system they've been served. Have they been served?
I know that citations have been issued, Your Honor. I'm not 100% sure if service has been effectuated at this time.
Okay. It looks like these citations were just issued today. Is that right? Is that correct?
I'm looking at it right now, Your Honor. Oh yeah, it looks like they were just issued by the court on the 22nd day of July.
They're not issued by the court, they're issued by the clerks, but
yes, sir.
Yeah, I'm not going to reset anything until we have the party served, and if they request a continuance, I might consider it, but until they're served and make an appearance, I'm not going to move the trial setting. So what other issues do we have to deal with today?
Well, then I have a subsequent motion that it's a motion to strike plaintiffs' experts for improper disclosure and not producing their expert file when they were supposed to, and they didn't give me reports, and they did not give me expert, or did not present them for deposition. My expert designation deadline is August 1st. I have no idea what several of these people are going to say, and I'm at a real disadvantage here. So the alternative would be to ask the court to move my designation deadline so I can have time to get experts responsive to them, which you can do under 195. It does not specify when I can move or when.
So let me ask first, you're moving to strike Pierce, Bradford, and Dr. Jaramillo. Are those, let me see. Have you attached the designate? Let me see.
I believe I have, sir. Should have been Exhibit A to my motion.
It's a life care planner, an economist, and looks like the second life care planner. Is that right?
Or I believe a treating doctor or a life care planning doctor. I mean, that shows I don't really know what these people are doing.
It's an economist, Your Honor, a vocational rehabilitation counselor, and then a life care plan.
So this is interesting. Don't think I've seen this before. The way you listed this as documents that, for example, that Mr. Gibson reviewed and relied upon informing his mental impressions, opinions have been produced to and were produced by other counsel. I think you need to go into a little bit more detail than that. About what exactly they've reviewed.
Yes, Your Honor, and we're more than willing to do so.
All right, so you're ordered to do that. When is the expert designation deadline?
August 1st.
All right, we're going to extend that to September 1st. And then you're going to be ordered to produce a list of everything. If it's been produced, you can just do a list, but if not, you need to also produce anything referred to, relied on by the experts and the 5 retained experts in this case. And you're going to be required to do that within the next 14 days.
I'm sorry, within the next how many days?
14 days.
Okay.
So get me an order on that. That'll be on July. Just make sure it says at the beginning of the order, instead of on this day, that this was heard on July 22nd, 2024, over Zoom. Go ahead and share that with opposing counsel and get that to me by tomorrow.
Yes, sir, I can do that.
All right. Anything else, guys?
I believe that's it for me.
And then I'm happy to consider, once we get these other parties served, if you get them served, once they filed an appearance, if they want to move for continuance, I'm happy to discuss that with them. All right, guys.
Understood. Yes, Your Honor.
Give me an
Ryan, would
order.
you give me a call?
Yeah.
And you guys, you guys have a great rest of your day. Okay.
Thank you, Judge.
Thank you. Get that to me as soon as you can.
I will.
All right. You're all excused. The next hearing is Porto Lonnie Family Limited Partnership versus Fieldman. Are both sides here on that?
Yes, Your Honor. This is Shane Egball and my partner Levi McCatherine here on behalf of Sam Feldman, the TWRF Inc. and FRR and MJR Family Limited Partnership, who are the movements today.
Philip Kingston for plaintiff, Your Honor.
And Andrew Spaniel for the City of Dallas, Your Honor.
And Mr. Turner, are you here for this case too?
I am. Yes, sir. Yes, Your Honor.
Are you a party or an attorney?
Mr. Turner is our witness, Your Honor, and he's also representing Portolani on the subject matter before the court today.
Okay. All right, let's proceed, guys.
All right, Your Honor, just before we get started, so there's two issues said today. I think we set aside some time at that last after the last status conference. My clients and the Portolani family reached a Rule 11 regarding expedited discovery, if you'll recall, before the TI hearing that is set for July 31st. And there are some discovery disputes I'd like to bring to your attention following this motion to show cause. However, principally, we're here on this motion to show cause, and I can get into the underlying facts, the details as much as Your Honor would like. But as you'll recall, the court issued a temporary restraining order on July 3rd in this case, preserving the status quo that has effectively been in place for my client over the last 15 years, whereby my client's tenant, Lila Restaurant, has been provided 52 spots and sufficient parking across the street at the parking lot owned by the Portolani family over the last 15 years. Essentially, the TRO just says that 3309 McKinney has the right to use the parking spots on all 3 tracts, 52 of the 62 parking spots on all 3 tracts of land, which comprise the entire parking lot that is across the street, until the temporary injunction hearing on the 31st, which would bring them in compliance with the Dallas code and give them the sufficient parking that they need based on their square footage per the city code. On July 9th, the court held a status conference at which the Portolani had actually filed in this court first regarding the same agreement and the same issues that are before the court in our case. We didn't know about it. We kind of got ambushed with a fraud lawsuit when we showed up to argue the TRO here.
Give me 1 second. Can you go tell them to come in real quick? Just one of them come in.
No.
Can one of them come in so I can talk to them?
Yeah.
So, sir, I can do this after my hearings are done, but that may be a few minutes. So do you want to wait for a while, or do you want to just try to find another judge?
Well, we already went to the bottom floor, so I mean, I don't mind waiting.
Okay,
If you're
yeah.
available and you can do it after, I don't mind waiting.
Yeah, it may be, 20, 30 minutes.
That's fine.
Okay,
Thank you.
thank you. All right, go ahead.
So yes, Your Honor. So the Portolani family had actually filed their lawsuit first. We hadn't been served. We had reached out to them initially to cooperatively resolve this issue and come into compliance with the city and discuss the agreement. Instead of responding to us, they ambushed us with a fraud lawsuit. By the grace of God, both cases ended up before your court, so that Your Honor could see kind of everything that's that's taken place. Our petition was also before your court. Judge Munoz granted the TRO, saying that we have a right to use all 3 tracts of their parking lot, which is comprised of 17,300 square feet, 350 square feet. It's clearly stated in the remote parking agreement. At the status conference, the court extended the TRO in order for us to be able to have time to conduct mediation with the mediator of our choosing, which is set for the 29th with Mr. John DeGroot, and to conduct expedited discovery that we were supposed to agree upon and then bring before the court any issues we had. Shortly thereafter, once the TRO got extended until July 31st, we agreed to expedited discovery. We're getting ready for it. On July 17th, all of a sudden, I get another notice to vacate in direct defiance of the temporary restraining order. We're not even in possession of the premises. We're here to, the TRO is enforcing a restrictive covenant that runs with the property. It falls squarely within the jurisdiction of this court. From the beginning, the Portolani family and their counsel have been looking for an end around Your Honor's authority, this court's jurisdiction, and per se acted in a way that has
Who sent you the notice to vacate, the city or?
Mr. Kingston. So no, the city has been completely, they haven't done anything disruptive whatsoever. They've been in full compliance with Your Honor's orders. I don't even believe they formally appeared or answered in this lawsuit. They're not a party to our Rule 11 regarding discovery. This all has to do with the Portolani family and their lawyers. They knew they were under an injunction. They sent us a notice to vacate and then a form to terminate the subject agreement as proof of our vacation. When I immediately sent Mr. Kingston an email back saying, you're asking us to vacate the premises while this injunction is effective by Saturday, over the weekend where our business can be interrupted. Are you saying that you're not planning, or you're planning on interfering with our right to use the parking spots in violation of the TRO, as we put squarely on page 5 of my motion? Mr. Kingston replies, the TRO is a possession order. As for compliance with the order, we are not complying and have no intention of doing so. And since then, it appears that they've concocted this argument that this is not a lawsuit to reform and enforce a restrictive covenant, the subject matter of which falls squarely within the jurisdiction of this court, but instead this is somehow a forcible detainer lawsuit that falls in the exclusive jurisdiction of a justice of the peace court, and they are treating us as if we are tenants in possession of the property, which we are not. This is simply a restrictive covenant, as the court has already noted, runs with the land. They fully have the jurisdiction to enforce it. If that's corroborated by the fact that the Portolani family first filed in this court and then signed, prepared a consolidation order that specifically states that our action and their action involves such similar issues that they need to be consolidated in the same cause number, and then sought consolidation of the actions, to which we agreed to avoid being difficult. But in doing so, in both filing that lawsuit and then agreeing and seeking the consolidation, they have submitted to this court's jurisdiction, Your Honor. And it's just simply not what they are trying to conflate the issues to be. This is not an eviction lawsuit. The citations that they have provided do exclusively deal with landlord-tenant issues and leases of premises. They have and immediate rights to possession of those properties as a result of those leases. They have nothing to do with restrictive covenants that run with the land, such as this one, and simply don't give us
I get it. Let me hear from Mr. Kingston.
Hello, Your Honor. I'm not sure what we're here on today, but Rule 692 requires any motion to enforce an injunction or for disobedience of an injunction to be verified, and it is not. I don't think we're properly here.
Your Honor, I can share my screen right now and put before you an email from Mr. Kingston to me that's in our motion, squarely in our motion, that shows you their defiance of the order. I believe that it's self-authenticating. However, Mr. Kingston can answer questions about it if you see fit.
Nothing that Mr. Egbal is saying allows him to comply with 692. He could have verified the motion, but he did not.
Your Honor, there's nothing that I've seen that says I have to specifically verify a motion that puts misconduct from counsel to this extent before the court. It was all in an emergency. It was done in an emergency context. They're telling us in the middle of an injunction being effective on a Wednesday that they're going to interrupt our business starting on a Saturday. Obviously, Lila is an evening restaurant. Its main business occurs on a Saturday night. I think this defiance speaks for itself. Again, it's squarely, if I may share my screen, Your Honor. It falls.
I mean, I think Mr. Kingston is technically correct that this motion does require an affidavit under Rule 692. I will, and also the second thing I will say is, Mr. Turner the one who's violating the injunction?
No, no one is violating the injunction, Your Honor, except that the injunction is impossible to comply with. We have continued to avoid entering into the property. We've done nothing to frustrate the defendant's use of the property. The problem is that the order requires us to provide 52 spaces, and there aren't 52 spaces there.
Mr. Kingston, why would you send I'm not going to put your guy in jail today, but why would you say that you want them to vacate use of the, let's say there isn't 52. I don't know if there is or not. I know that's contested, but a motion to vacate clearly violates this order, whether you agree with it or not, whether you thought it violates the order. Mandamus me, mandamus Judge Munoz, whatever you want to do, but that would clearly be in violation of the order. I agree that Mr. Egbal, we need to cross our, dot our I's and cross our T's here. And so you need to file a verified or a motion for show cause with a affidavit attached. But I will say to you, Mr. Kingston, and you, Mr. Turner, if they do that and you've really done what they say that you've done, I have no problem, Mr. Turner, with putting you in jail until you comply. So, but today I can't do anything. So we'll, how quickly can you get an affidavit and get this on file, Mr. Egbal?
I can do it in the next 30 minutes, Your Honor. All I have to do is verify this petition and file it with the court.
I think you need an affidavit, don't you?
I mean,
Your Honor, we'll look at the rule and comply within the next hour. So,
okay. In case of such obedience, the complainant, his agent, or attorney may file in the court in which such injunction is pending, or with the judge in vacation, his affidavit. So you need. It sounds like the attorney can file it under Rule 692. I'm happy to hear this tomorrow morning. I'd like Mr. Turner, once that gets filed, to be here in person so that if we need to, we can put him in jail. And we'll go from there. All right, guys. So if this gets on file, I'm going to order it to you guys to be down here at 9 a.m. All right?
In person. Yes, yes, Your Honor. Thank you
Thank you,
very
Your
much.
Honor.
Take care.
If there's a defect, we'll deal with it tomorrow. We'll see y'all in the morning at 9. Mr. Turner, you're expected to be here. Bring
All
your
right, I'll
toothbrush.
be there.
Thank
Make
you,
sure
Your
to bring your toothbrush.
Okay.
Okay, Beams versus Wingfield. Are you guys both here? Beams versus Wingfield. Anyone here on that case? Mr. Kingston, we'll see you in the morning, okay?
I'm sorry, Your Honor, we had a Wi-Fi problem at our office. What would you like me to do in the morning?
You'll need to come down here with your client, assuming that they file a corrected motion, and we'll have to make a determination whether to put them in jail, okay?
Yes, Your Honor.
All right, we'll see you guys in the morning. Okay, everybody, Tony, well, it looks like our trial docket may be going away. We have one case left, and remediation. So, do you guys have any, we have a couple status conferences and things like that. You're welcome to do this remotely, Tony, if you'd like, but everyone else here, I guess, ways, if you still have COVID, you can appear remotely. Everyone else, show up in person, okay? You let them in. Do you guys have any questions?
Have a good evening.
Thank you.